going to be accreditation, the Mediation Council of India, the standards of mediators, and how to ensure quality and accountability in mediation. Considering that the introductions are already done, I leave the floor to the Chair, Honorable Justice Prashant Kumar Mishra, Judge, Supreme Court of India.
Esteemed Brother Justice Arun Bansali, Chief Justice of High Court of Allahabad, Brother Sanjeev Sachdeva, Chief Justice of High Court of Madhya Pradesh, Justice G. Narendra, Chief Justice of High Court of Uttarakhand, Justice Sujit Narayan Prasad, Judge, High Court of Jharkhand, Justice M.I. Arun, Judge, High Court of Karnataka, Amit Kumar, Advocate General of Meghalaya, Sri Anil Singh, Additional Solicitor General, High Court of Maharashtra, Sri S.D. Sanjay, Additional Solicitor General, Supreme Court of India, Learned Attorney General, the Chief Justices of different High Courts, including Odisha and Gujarat, and Delhi and Chennai, my esteemed sister and brother judges from different High Courts, the trained mediators, participants, ladies and gentlemen, we have been requested to wrap up the session at the earliest. Though we thought that development of an institution is the most important area for any institution, but as the coincidence is that the deliberations would not be much longer, and it will not be to the satisfaction of the panelists, but still we'll try to focus on the key areas of the development of institutional mediation. And as we know, after this enactment of the Mediation Act 2023, the process of development of institutional mediation has already begun. Some of the provisions have been notified, some have not been, and there has been discussion throughout the day as to whether the provisions which have not yet been notified should be notified at the earliest. And another interesting thing is that the focus areas of this technical session is devoted to Mediation Council of India and standards for mediators and service providers, and accreditation, mediation councils and recognition of bodies, and those provisions are yet to be notified. So now the, in fact, focus for this technical session should be, if we shift the onus will shift to the Attorney General, so that it is notified and the focus remains focused in real terms. Anyways, there are provisions in different enactments ensuring institutional mediation, and those are the provisions contained in Hindu Marriage Act, then MSME Act, Consumer Protection Act, Commercial Courts Act, CPC. All those enactments provide for an institutional mediation. Sometimes they are resorted to, sometimes the judges manning the courts, they don't resort to, they are hesitant to resort to at the beginning, and it happens so most of the time because the litigants are also hesitant in going for mediation at the threshold. Unless it's a commercial dispute where the parties have their own financial and commercial stakes, the other parties in the traditional litigation, they, because of problem of ego, they don't resort to mediation at the threshold. After spending some time in the litigation, maybe 6 months, year, 1.5 years, they reconcile that it is better to go for mediation and settle this dispute and live in peace. And with this peace word, I am reminded of the focus on peace mediation rather than procedural and other mediation and commercial mediation. When we say commercial mediation or any other mediation, contrasting to peace mediation, when you buy peace through mediation in the litigation, and even before the litigation begins, if the peace can be bought without resorting to litigation, with peace you grow. If the parties adopt mediation and adopt peace, then they grow in a better way in their own field, whether be it a dispute of title or be it a dispute of commercial nature or be it a dispute of marital relationship. So the point is that peace mediation includes every kind of mediation. And as we have been telling it, that mediation is always for peace, like it is said in Ramayana or Mahabharata, and you see the other religious texts, including Buddhism, Bible, and Quran, all have preached dialogues for settlement of disputes. The mediation has been there since time immemorial, and the need for institutionalization of mediation is much more required, and rather it is inevitable today. The kind of pressure of litigation we are facing, mediation is one such area which will reduce litigation and bring prosperity to the warring parties to achieve their goals in life, in every walks of life. One of the most focused area of building an institution is capacity building. We have to build capacity. I am just giving the bullet points. Capacity building is the most important area to build an institution. We have to train the mediators in huge numbers, because as in the earlier session, one honorable speaker was saying that 65% of the India's population lives in rural areas. So this mediation is not only for rich and prosperous people, it should be brought to the ground level. It should be made available to the man in the villages. So we may consider building this capacity building and institutionalization to be brought to the district level or to the block level or to the panchayat level, where trained mediators would be available in due course to provide the required facilitation for the parties and somebody who is there to convince the parties at the grassroots level to curb the litigation even before it begins. So that should be the idea and spirit, to build an institution of mediation. Institutionalization will come after we build an institution called mediation. That is how we will proceed, and time is less. I will request the speakers to please cooperate and finish up as early as possible. I will request first Justice Bhansali And Mr. Justice Seva would wrap up in the last after the other speakers would finish.
Thank you, sir. Respected chair, co-chair, all the participants on the dais and in the audience. The theme of the session is development of institutional mediation. Now, we start with what institutional mediation means. It can be described as a process where parties agree to use an institution with established mediation centers and specialized mediators to resolve their commercial or other disputes. The Mediation Act 2023 facilitates such mediation by establishing the Mediation Council of India, promoting community mediation and online mediation, and by providing for the enforcement of mediated settlement agreements. Now, why institutional mediation? What are the advantages of having a institutional mediation? The institutional mediation makes a shift from the ad hoc mediation towards institutional framework to bring standardization, accountability and neutrality. The problem of uneven quality, lack of accountability, lack of accreditation and absence of regulatory oversight is taken care of. The Act of 2023 in India explicitly envisages institutional mediation and a regulatory body, Mediation Council of India, to oversee the institutional mediation. The institutional mediation would further lead to faster resolution, consistency in process, greater trust from parties, and reducing the burden on the courts. The Act provides for the statutory provisions for institutional mediation under Chapter 8 and 9 with Mediation Council of India, mediation service providers and mediation institutions, their registration, recognition and related regulatory powers, their duties, functions, guidelines, regulation, registration, suspension, cancellation, etc. is taken care of. The regulations pertaining to their working is required to be made by the Mediation Council of India pertaining to qualification, assessment, accreditation, suspension, cancellation, etc. under the Act. Now, the role of Mediation Council of India is primary under the Act of 2023 for the purpose of making happen the institutional mediation. The mandate and the functions which have been indicated under section 38 pertains to framing the regulations, standards, guidelines for professional and ethical conduct of mediators, service providers and mediation institutes, recognize, renew, withdraw the recognition of mediation service providers and mediation institutes, maintain an electronic depository, registry of mediated settlement agreements subject to confidentiality safeguards, monitor compliance, audit, review of MSPs and mediators, report annually to the central government on implementation of the Act, promote mediation domestically and internationally, the awareness, outreach, training, research and the best practices. Now the challenges and practicalities of the working of the Mediation Council, the first and foremost is establishing the Mediation Council itself. Now recently, when I was searching for it, I read it somewhere. Recently the law minister in one of the speeches said that it is at an advanced stage of constitution. Then its staffing, governance, its independence, funding of the Mediation Council, which may require infrastructure, systems, and human capital, ensuring legitimacy by involving the stakeholders, that is the judiciary, mediation community, and user parties in its governance and standard setting, avoiding over-regulation or over-bureaucratization, striking balance between oversight and flexibility, take care of conflict of interest, shielding political interference, ensuring autonomy. The most important thing would be transitioning the existing institutions and mediators into the MCI regime without disruption, handling complaints, appeals, reviews, discipline by the adjudicatory arm or overseas committee which may be required, ensuring data protection, confidentiality of registry, preventing misuse of the settlement data, international cooperation and alignment would also be required. What would be required also would be to standardize the standards for the mediators and service providers for whom the core ethical and professional standards would be impartiality and neutrality, no bias, no predisposition, must disclose if there is any conflict which is provided in the Act itself. They must be independent, should maintain confidentiality, there should be self-determination by the parties. The mediator should not coerce or impose terms. There should be competence and continuous training for the mediators. They should follow due process and have procedural fairness, ensuring parties have a chance to be heard, understood, and there should be a meaningful participation. There should be transparency in the fees to be charged, costs which are to be borne by the parties. The record keeping and documentation also would be a very important thing, wherein the confidentiality will have to be maintained. The performance evaluation of the mediators from time to time, that will also enhance their quality. And what would also be required is to have the standards for the service providers, like what infrastructure would be required from them, having secretarial support, neutrality of the administration, selection, rotation of the panel, conflict systems, process, rules, transparency, complaint mechanism, etc. So the sum and substance, or the bottom line of the entire issue is that first and foremost is that the MCI should come into being, and the regulations for its working, they have to be framed, which will be the bedrock on which the institutional mediation can thereafter proceed. Thank you.
Thank you, Justice Bhansali, and I especially thank Justice Prashant Kumar Mishra for his rather pragmatic and insightful comments. With this, we now go to the next participant, Honorable Justice Guhanathan Narendra, Chief Justice, High Court of Uttarakhand, to share his views on the theme for this session.
Honorable Chair, dignitaries on the dais and off the dais, ladies and gentlemen. My brother, Chief Justice Arun Bansali has done a complete overview of the Act, leaving no scope for me delving into it. So I'll just take off on a slightly different path. Mediation is rudimentary and as primitive as civilization. Especially in our culture, in the backdrop of the joint families that we witnessed earlier, any dispute between siblings or between in-laws, you had the others stepping in, the other elders in the family stepping in and mediating. Even as on today, we find the husband mediating between the mother and the wife, between the father and the children, to bring about peace at home. So initially this mediation, if you see the objective, in earlier times the objective was peace. Was some of the two of the earliest and most celebrated events of mediation, as His Lordship Justice J.K. Maheshwari was mentioning, was the attempt by Angad and his Lord Krishna. If we look at the timing of that attempt, when both parties were at the doorstep of war, yet the parties thought of mediation even at that critical time. And what made that attempt possible was the stature of the parties who were proposed for undertaking the mediation. I refer to this with reference to the quality and the standard of mediators that we need to create. The stature of a mediator is very relevant, because if the mediator and the stature is known, it draws away the initial hurdle of mistrust in the parties. The mediator is an unknown quantity, and the parties reposing trust in him would not be a short-term affair. So, if persons of stature, and how do we create persons of stature? We must profile them, and we must place this profile in public domain. And people today, with the access to information technology, it would help in them knowing about the mediator, and that would help them to repose trust in the mediator. And when trust is reposed, we can expect quick and easy resolutions. With regard to institutionalization, yes, there is no, I don't think there can be a second opinion. It is the onerous task which the state will have to take up upon itself. Without the state's helping hand and aid, I don't think it would be possible to create infrastructure. And infrastructure has to be from the district levels. Person speaking the local dialect, an arbitrator speaking the local dialect, an arbitrator who is a local and fluent in the local language and the practices, will be more successful in convincing the parties to think of an alternative, rather than sticking on to litigation and trying to achieve the objectives through litigation itself. Just, but at the same time, should when speaking of standardization, should standardization be taken to such an extent where it could lead to rigidity? Can standardization of accreditation standards or qualifications, can they lead to stereotyping? I think flexibility in approach and flexibility in assessing the parties is crucial for mediation to be a success. If we allow rigidity to enter the process in the form of standardizing qualifications or practices, probably we may again be going the arbitration way. And the arbitrators, mediators may make an effort, but asking for accountability would in my opinion be a little, placing a little more burden on the mediator. The main attraction of mediation is the freedom, is the latitude that the parties get with regard to the process, with regard to the person. And if somewhere down the line we are going to say, no, it is A who will do it or B who will do it, probably then it may, especially in cases involving personal relationship like matrimonial cases or partition cases. I think if the system is going to impose somebody, probably there may be some resistance and it may be a little more time consuming. And if it is left to their choice, if the mediator is a person of their choice, there is every possibility that the process can quicken. There are several techniques of mediation, and person should not only be a good mind reader, he should also be a good counselor. Unless he can assess and second guess the parties, and he cannot be a step ahead of the parties before him. In view of the time constraint, I would like to, with the permission of the chair, I'll close my presentation. And I thank the organizers for having given me this opportunity, this wonderful opportunity to be part of this wonderful occasion. Thank you.
Thank you, Justice Guhanathan Narendra, for your engaging comments on today's theme. With this, we will move on to our next participant, Honorable Justice Sujit Narayan Prasad, Judge, High Court of Jharkhand.
Thanks to the chair, co-chair, and all the panelists, my esteemed sister and brother judges, Honorable Mr. Justice Sanjay Karol, the Judge, Supreme Court of India, the Chief Justices of Bombay High Court, Gujarat High Court, and the Madras High Court, all the participants, a very good evening to everyone. That we are discussing about the institutionalization of the mediation, issue of mediation. We know that mediation, we have talked about the Ramayana era, the Mahabharata era, the Vedic era, known as the Panch Parameswar. The Parameswar have been said by the people of the Panchas due to have the faith upon the Panchas. The faith is the cornerstone of the mediation. The trust upon the person who is functioning as a mediator for the settlement of the dispute. Now, for the first time in 1989, the CPC, the section 89 has been, the formal institutionalization of the system of mediation has been taken note by the parliamentarian, but it was still to be institutionalized. Now, the Mediation Act has come in 2023. The Mediation Council has been proposed to be constituted in view of the provision of section 31 thereof, but still it has not been given effect to. The Government of India is working upon it, but the question is that this can be a challenge, but whether on the basis of that challenge we can tie our hand, that is the thing to be deliberated upon today on this issue, because we all know that the mediators are working under the guidance of MCPC. MCPC is working under the auspices of NALSA, and on the basis of instruction of the NALSA, the SALSAs, and on the basis of the instruction of SALSA, the DALSAs are working to have a chain of the system of mediation also, in addition to the settlement of the dispute through the Lok Adalas, the state level and the national level. So, during the intervening period, when until the date of establishment of the Mediation Council of India as a regulatory body, that we have to take care of through this system which we are carrying out under the control of the judicial system in the administrative side. The development depends upon the regulation of the body. In absence of regulation, there cannot be a development. So, regulatory body is required, but we cannot wait that so long as the Government of India will not come out with the regulatory body, the system is to give and go by. We are having the State Legal Services Authority, the district level services authority, and we are appointing the mediators also, giving training of 40 hours on the auspices of the MCPC, guided by the instruction of the NALSA. So, we have to take care of till the Mediation Council is being instituted by the notification to be issued by the Government of India. Because mediation, if we will wait for the establishment of the Medical Council of India, then what will happen to the statutory mandate as contained under section 89 of the CPC, and the faith of the people and the overburdening of the courts of the pending litigation. And moreover, if the issue will be settled through mediation, then certainly that there will be no appeal, there will be no further appeal to the apex body, that is the Honorable Apex Court. So, by that a faith will come upon the people, will be in a position to have that trust upon the people, and the people will have that through mediation also the settlement is possible. Then question is how the trust will come. The trust is on the scrutiny of the appointment of the mediators, on the basis of their integrity, on the basis of their expertise on subject, and moreover working without any vice of malice and showing any opinion, by having impression upon the litigants that the mediator is having idea to support one of the party. So, that my opinion would be that so long as the central government is coming with the Mediation Council of India, we are having with the system, through the SALSA, through the DALSA, we have to look into, and I must say that as a executive chairman of the State Legal Services Authority in the state of Jharkhand, that I have tried to engage the mediator on the basis of their absolute integrity, and integrity cannot be tested in one day, that I understand, but I used to review the functioning of the mediator periodically by getting report regarding the proceeding of mediation, whether it is unnecessary adjournment, and how many adjournment, why the adjournment has been given, whether the parties are appearing or not. Being conscious with the fact that the depanelment of the mediator is not permissible. So orally I have instructed that if such is the attitude of the mediators, then don't give any proceeding to any matter to the mediator at least for a period of 3 months, so that they have an idea in their mind that if they will do, then they will not be given any matter for the purpose of mediation. And that I personally got the result, and I have got the data that up to the month of August 2025, cases referred was 26,040, and through mediation the number of settled dispute was 9,652. And the special drive, total identified matter was 52,406. Referred number of cases was 11,382. Successful 3,814. Unsettled 2,987. And still pending 4,288. So the figure of the successful mediation was 33.51%, unsettled 26.26%, and the pending litigation is 37.6%. So I will not take much time. That can be a challenge for us, that the mediation council is not there, infrastructure is not there, but you have to work. And we have to introspect that how on the available system and the situation, how to work. So with these words, I am extremely thankful to the organizer in giving me opportunity to address on the issue, and I understand that it is a very sensitive issue for the purpose of softening the litigation and settling the issue at the stage of pre-litigation itself. Thank you very much.
Thank you, Justice Prasad, for showing us a real-world application of institutional mediation. We now move on to Honorable Justice M.I. Arun, Judge, High Court of Karnataka, for sharing his thoughts on institutional mediation.
Honorable Chair, dignitaries on the dais, off the dais, ladies and gentlemen. Why institutional mediation? Why does it matter? Now, we have the concept of mediation with us, but to make it an effective tool for dispute resolution, we need to have institutions. If we do not have institutions, we cannot implement the concept of mediation properly. Now, these institutions, they ensure credibility. Properly, if it is structured, definitely they can ensure credibility, neutrality, and fairness in the mediation proceedings. And then it can provide for infrastructure and trained mediators, and it can see to it that settlement agreements that are reached in mediation are legally enforceable. Even that's a very important concept which has been discussed from morning today. Now, coming to the institutions, there are other legislations apart from the Mediation Act where we have where they do envisage mediations and institutions to deal with mediations. But I should say the Mediation Act 2023 is a fantastic piece of legislation. Kudos to the Parliament which has passed this and enacted it. It really puts India on the global stage. Now, if we look at this Mediation Act, though of course not all provisions are notified, it does envisage firstly creation of Mediation Council of India. It's a central statutory body created under the Act. Now, what are its key duties? Firstly, regulating and oversight of mediation ecosystem. That's very important. Next, it registers mediators. It seeks to register mediators, recognize mediation service providers and mediation institutions. Then it envisages to lay down standards for mediator training, certification, continuous education, which is very essential. Just like advocates and even for judges, we say continuous legal education is essential. It is essential for mediators also. MCA can do it. Then to determine manner of mediation, proceedings, registration of mediated settlement agreements, then promote domestic and international mediation and awareness building. Then after this Mediation Council of India, the Act also envisages to establish mediation service providers. Now, these may include bodies or organizations. It can be private or public, which are recognized by Mediation Council of India, authorities constituted under the Legal Services Authorities Act, then court-annexed mediation centers also, and any other bodies which can be notified by the central government, which is very key for implementing the concept of mediation in India. Now, this particular MSP, that mediation service providers, they can accredit mediators, maintain and manage a panel of mediators, which is very essential. Everything is not possible to be done by MCI. It has to do its, that ecosystem that is created has to be implemented through these MSPs. Then it can provide facilities, infrastructure, secretarial assistance, etc. for conducting mediation. Then it can promote ethical and professional conduct among mediators. It is very essential. Then it can facilitate registration of mediated settlement agreements. Now, all these things are possible only if MSPs function properly, and establishment of this particular institution as envisaged under the Mediation Act is very important. Then we have mediation institutes that are envisaged under the Act, and these are bodies recognized by the Council to perform functions like training, continuous education and certification of mediators. And it will provide those things, and it will only supplement the purpose for which MSPs are established. Then last but not the least, we have this court-annexed mediation centers, that is legal services authorities and other authorities, which are already functioning, and they have been instrumental in seeing to it that mediation is promoted in India. Now, mediation, dear friends, is something that can resolve the dispute finally, without any problem. There won't be any animosity between the parties as opposed to adversarial system. Now, much has been said about mediation being very ancient. Yes, it is very ancient. From Ramayana, Mahabharata, it has been quoted. Now, I thought being in Odisha, in the land of Kharvela, I need to bring out certain other fact also. You have this Udaygiri and Kandagiri case just outside Bhubaneswar. He was an ardent devotee of Bhagavan Mahavir, and there was a concept called Anekantavad. Now, the absolute truth can be realized by an enlightened soul. That is what is said over there. For an ordinary human beings, we realize the real truth. We can resolve a dispute only when we hear all points of view. Now, this may not be completely possible in an adversarial system, but this is possible in mediation. Many a times a litigation is filed with a particular prayer, but that will not be the real objective. The real objective will be something else. That can be realized and understood in mediation, where the parties can open up and all views to the dispute can be brought forth, so that there is a permanent settlement. Well, it's already late in the day. I don't want to take much time. Thank you, one and all.
Thank you, Honorable Justice M.I. Arun, for showing us the core action areas, I believe, for the future. We now move on to the team of government lawyers on the panel. I start with Mr. Arun Kumar, Advocate General, State of Meghalaya, to share his thoughts on the theme.
Thank you, Chairman. Dignitaries on the dais, dignitaries of the dais. I am at the fag end of this session, and my iPad battery is also going down, so I will be as brief as possible. The idea of community mediation, which Justice Ashutosh Kumar highlighted, Justice Kosi highlighted, and certain examples have been cited of the countries in San Francisco and other parts. Since I come from the Northeast and I come from Meghalaya, we have this community mediation in practice as on today, and it has been since time immemorial also. For example, in Khasis settle their disputes in most of their family, land and other petty disputes at the level of Darbar Sanon. Similarly, we have the institution like Nokma for Garo tribe in the state of Meghalaya, so we do not see too many disputes coming to the courts or formal structure, because they settle their dispute through mediation at those levels. Learned Attorney General before the session reminded me that they are the real stakeholders and they should also be heard and seen in August gathering, that those practices which are being followed in Northeast, especially in Meghalaya and Mizoram, where elderly councils decide the matters. There are some aberrations which they do in practice, but by and large, the practices followed in mediation by these communities have been helpful to the state. And in this context, what we have to notice is that now Section 2H of the Act talks about the community mediation. Now, when we go for community mediation and formal structure, under Chapter 10, if I am not wrong, Chapter 10, the issue is whether mediations which are carried out by these institutions will get recognized under the new Act or not. So, we need to ponder, we need to see and at least recognize the best practices which we have in northeastern parts of India. That is one aspect of the matter. Second aspect is the question of how do we strengthen our institutions, how do we strengthen them, because what the Act is doing is making, as previous speaker has pointed out, that it is formalizing the institutional mediation by recognizing mediation service providers and mediation institute. And therefore, the purpose of institutionalization is to create trained mediators, inculcate better ethics, predictable panels and infrastructure and ease. These are the measures which we are required to adopt and do it, and we have some example in arbitration. I can cite one example of Delhi International Council, which is very DCI, if I am not wrong, that we have, and they have set the standards. So once we have this Mediation Council of India and the best practices are followed, including the practices which are being followed by Singapore International Arbitration, we may see the day where most of the disputes are getting resolved through the mediation process. At the same time, the purpose of this mediation is, one is saying that to ease the burden of the court, but it is quick, fair and enforceable. That is the beauty of the new Act. And in my opinion, in very short summation, the path to success is we have to establish the institutional credibility, integration with culture and Indian perspective, trust building and access and outreach. If we follow all these measures, I am hopeful that the mediation will be successful, and it is the idea of the day, and as Victor Hugo said, that nothing is more powerful than the idea whose time has come. And in my opinion, idea of mediation to way forward in our journey to access truth and justice. With these few words, with the permission of Chair, I conclude.
Thank you, Mr. Amit Kumar, for sharing your experience from the Northeast. We now move on to Mr. Anil Singh, Additional Solicitor General, High Court of Maharashtra.
Co-chair, dignitaries on the dais, off the dais, ladies and gentlemen. Since yesterday we have been discussing on a main issue that the lawyers will play a very important role in success of mediation. Unless the lawyers, the Bar Association, the Bar Council of the State Bar Council and the Bar Council of India, they support mediation program, the program or the movement of mediation won't be successful. This reminds me, way back in 2010, when I was a chairman of the Bar Council of Maharashtra and Goa, we had a conference on mediation. Justice Ravindran, the then Supreme Court judge who was in charge of all mediation program then. He had visited Maharashtra. And then he was narrating a story. He told us that he was watching a TV program and the channel had a very interesting topic. The topic was, are we afraid of courts and lawyers? Surprisingly, each and every participant present in the program answered, yes, we are afraid of courts and lawyers. In our democratic setup, if such type of impression is gathered by the ordinary people, by the common man, it's really a dangerous setup, dangerous trend. Then we were told at that time, I'm talking about 2010-11, when the mediation movement was at its initial stages, that 40 to 50% of potential litigants, they are not approaching court. The reasons given are all usual reasons which we know: delay, cumbersome procedure, heavy cost of litigation, and all those infrastructure, then cumbersome procedure, all those reasons were given. And then on the discussion, it came to us, to our notice, that the best solution would be the alternate dispute resolution mechanism, and that is by mediation. Slowly and gradually we have made a lot of progress in mediation. Now the government has, since last 10-12 years, has taken a lot of initiative in mediation, and mediation program has been becoming successful day by day. But still, I must tell you that when somebody told in the morning and yesterday also, that this has to be inculcated since beginning, when you are either joining the profession or when you are studying as a law student. Otherwise, as a law student, you are not aware of what is this mediation program, how mediation takes place, and if a client comes to you, you can also suggest a via media of mediation, especially junior lawyers, and it is our experience in Maharashtra that when we were conducting mediation programs in Maharashtra, some junior lawyers, they used to come in the program, they used to say that you are all senior lawyers practicing since last so many years, you have learned a lot. हमारा तो भी कमाने का दिन, अगर हम मैटर छोड़ देंगे तो कैसे चलेगा mediation? So this is what the impression was gathered, and therefore we require to educate those lawyers, the junior lawyers, and tell them that, see, you are benefited ultimately if your client gets a result immediately. If the matter gets settled, you can charge more fees, you can get more matters, people will have more confidence in the system. So this is what needs to be told to the junior lawyers, to the young lawyers, and even to the law student. And therefore I fully agree that this has to be inculcated right from the beginning. So whether you go for institutional mediation or ad hoc mediation, success of mediation will certainly depend upon the legal fraternity, the lawyers, because 95% of the litigants or a common man who goes to a lawyer, he will rely or he will trust what the lawyer says, and accordingly he will act upon. Now coming to the point of institutional mediation. Now we all know, and it has been already spoken by my previous speakers, so I will not repeat it. The theme has been, the theme of the session, that is development of institutional mediation, is a subject that is fast becoming final, fast becoming central, and and will be the future to dispute resolution mechanism. Several institutions are developed providing structured mediation and recognized as credible and effective alternate to litigation. Private mediation centers have been developed and have been increasing day by day. There are a lot of mediation centers private in Maharashtra, in Mumbai, in Pune, in Nagpur, and we are all taking advantage of all those institutions. Though we had some provisions earlier of mediation in Industrial Dispute Act, we had Lok Adalat, mediation under the Arbitration and Conciliation Act, Family Court Act 1984, Commercial Court Act 2015. The Supreme Court emphasized the need of dedicated legal framework for mediation in India, recommending enactment of Mediation Act as a standalone act and establishment of Mediation Council to regulate training and ethical standard. This was in the case of M.R. Krishnamurthy, and thereafter the act has come into force now. We all know that the preamble of the act states that it is an act to promote and facilitate mediation, especially institutional mediation. Therefore, the emphasis is on institutional mediation, which will include pre-litigation mediation, online mediation, and community mediation also. Several advantages of mediation has been already spoken. We have seen the credibility because the parties trust the process when it is backed by a recognized institution. Neutral and trained mediators we have in the institution, confidentiality and enforceability of settlement agreement. The proceedings are more streamlined, which avoids unnecessary delay. It's more accessible, and it is available to the ordinary citizen. It preserves relationship and fosters cooperation, provides all facilities, assistance, infrastructure, logistic, and other administrative support. So this is how we have a lot of advantage of mediation, and one of the most important benefit of mediation institution is because if you go to a mediation institution, it avoids a lot of wastage of time by having agreement ready in hand. When institution is mentioned, parties are bound by the mediation rules like venue, language, fees, time frame, etc. And therefore the process is more effective, less burdensome, and also cost effective, and the parties are bound by that. We have been told about the importance of mediation council. Once it comes in force, certainly it will be helpful in the entire progress of mediation. Justice Arun has already stated, I will not repeat it. And therefore we are all aware that how mediation has been successfully progressing day by day, and certainly this program and this seminar which we have held today and conferences like this will help in future also for the progress of mediation. And one of the most important thing is that when you go to a mediation center or institution, you get a specialized team who are working. They are expert in their field, as it was already mentioned in the morning, that when you are practicing in a family court or you know the family dispute, you can't resolve, or if you don't know commercial dispute, it is very difficult to handle such situation and settle the matter, or to draw or to draft a document of settlement. And therefore it is always preferable that you have an expert team, and this is always available when you have an institution. So that is a benefit of institutional mediation. I will just give one illustration, one illustration, and then I'll close. One of my junior who is practicing with me, he said that when he was studying in US and when he was doing his masters, he had visited the small causes court in a city of America. When the matter was going on in court, the matter was being argued. Suppose the court had called the first matter, and 10 or 15 litigants are waiting for their matter. The court had trained mediators, and that court had tie-up with some institutional mediation center. And that mediator, he was sitting in the court or in the next room attached to the court. The litigants were requested that if you want to settle your matter till your matter is called out, because otherwise also you are waiting for a matter, why don't you try and get your matter settled through a mediator if it is possible? Otherwise, we will not adjourn the matter, we will go on with our matter. I am told that there has been successful result of such suggestion which was working well in the court. I can suggest here also that even in courts also, if we have a tie-up with some mediation centers who are recognized and are well reputed, then we can have trained mediators even in the court. And because we know that in our court, we have on board large number of matters in the court. There are many matters listed. It is not possible that every matter reaches on the same day. We have sufficient time. At that time, we can suggest the litigants who are in the court, especially in the district courts, that why don't you try and go for settlement, because the mediator is available here. And if it is not settled, the matter can be taken up without adjourning the matter and without wasting time. So this is one suggestion which I am giving as far as the mediation institution and working of mediation is concerned. Thank you very much.
Thank you, Mr. Anil Singh, for sharing your lucid thoughts on the subject. I now move on to Mr. S.D. Sanjay, Additional Solicitor General, Supreme Court of India.
I presume that I am the last panelist in this whole session. Everyone must be very tired, so I will be very brief. Honorable the Chairman, distinguished judges on the dais and off the dais, I only want to add few words, although everything has been said in the whole day deliberation. One thing I want to point out, right from the morning we have been discussing two important events in the past. One was of Ramayana, another was of Mahabharata, where attempt for mediation was made, but it failed. But then I want to remind that one of the most important historical event of modern India was our independence. We achieved this independence by mediation, and the starting point was calling of Mahatma Gandhi in Round Table Conference in England, and thereafter continuous effort was made. Finally, it led to our independence. So this is one of the successful example of mediation in the history. Now, therefore, we are deliberating here for future, and we have to look back what were the problems which has been faced by this robust system, how we have to make it a robust system. I have few suggestions to make. This act has come in 2023, but even before this act, there has been effort of mediation. Now the first thing is to identify the areas in which it can be successful. Nowadays, I find that courts are being flooded with the matrimonial disputes. Even the Supreme Court, every day we see, before every court, the cases of family disputes, matrimonial discord are coming either by way of transfer petitions or otherwise, and people are bringing it to expedite solution of this dispute, because when the matter goes to the family court, it takes 5 years or more than 5 years in the settlement of dispute. But when the matter comes to Supreme Court in this way or that way, in exercise of power under Article 142, it is granted, but before that, the Honorable Supreme Court grant opportunity to go in mediation. In similar fashion, the matter goes to the High Court, but then power under Article 142 is not available to the High Court. So therefore, the cases are coming. So first things to make this institutional mediation system to be more effective and robust, we have to identify the areas. Now once the areas like family disputes are there, then lot of civil matters like partition in the family are going in the court. They can be resolved through mediation. So from the ground level, it has to be improved. Now first thing we have to do is, now the government has taken initiative and 2023 Act has come into force. Now this mediation has to be put in the curriculum of these students, in the schools, in the law colleges, that this has to be encouraged. Now I say not only the role of lawyers, the role of honorable judges also become very important, because people have lot of faith in the system. So if it comes from them, they have to believe it, and they believe that, and then their trust enhances that yes, when it is coming from the judges, like in the High Court or Supreme Court, when the matter is referred to mediation, then they say all right. And then thereafter the negotiation starts for this system. So we have to put it in the curriculum of students so that apart, like any other system, like Contract Act, constitutional laws, one subject should be introduced as mediation, in which the training should be started from that level only in the colleges, in the law colleges, and thereafter during the training of the lawyers. And then like there are law assistants in the high courts and Supreme Court, in similar manner, in order to make it effective and robust, that there should be training for them as a law assistants. Now it has to be made remunerative. Now like when in the law college the student goes, now he starts thinking in three ways. One is to become a litigation lawyer. Second is to become a judicial officer. Third is nowadays to go in corporate law, to join a company to do transactional business. Now similarly, now they have to think, they have to make it as a career. Now if it becomes remunerative, then they think to opt it as a career. And once it becomes that, now in our sessions, before this session, there were trained mediators. So they think of making their career in that field. Now so far as the law is concerned, it will take some time to develop, because every law when it comes, like even Arbitration Act, when it came initially, it was not developed that much. Now it is only past 20 years there has been development in arbitration, and nowadays after 2015 amendment it has taken the pace. Similarly, this mediation will also take time, and such type of deliberation really help in this making it further robust, and virtually this makes the people aware apart from everybody to go for this system. And I am quite positive and optimist that even the government is going to take decisions soon. Our Attorney General is sitting here, our Minister will also be there. So I think whatever deliberation has been done today in the morning session till now, they have taken note of it, and we as a law officer of the Government of India, we are also going to push it up to take it as a robust mechanism, not only to reduce the pendency of the cases in the courts, but also to give fullest satisfaction to the litigants, because this is the only mode through which they don't feel, it's a win-win situation and don't feel at a loss. I will not take much time, and I thank all of the organizers here, particularly Sri Acharya, Learned Advocate General, Odisha, for giving me this opportunity and organizing such a wonderful symposium on this subject. Thank you, sir.
Thank you, Mr. Sanjay, for your incisive and clear views on the subject. With this, we move on to the last speaker for this theme, Honorable Justice Sanjeev Sachdeva.
Thank you very much. Honorable Chair, Justice Mishra, dignitaries on the dais, off the dais, and all of you sitting there, coming in as the 43rd speaker for the day. With all of you still so attentive, shows the success of this conference, and the credit really goes to the Learned Advocate General, Mr. Pidambar Acharya. Now, talking about success stories, I'd like to share two success stories, one about Delhi and another about Madhya Pradesh. I was a trained mediator, I was a lawyer, then I became a trained mediator in Delhi, then I became a judge. So I have worn all the three hats, as it was discussed in the earlier session, that you have to change hats when you're a mediator. The Delhi High Court Mediation Conciliation Center, which we call as Samadhan, started on 24th September 2005. It was one of the first centers which were court annex centers which were set up in mediation. There was a lot of protest from the bar at that time. There were strikes which went on for several days. The judges who set up the center were adamant, no, it is going to be successful, because they had got experience from abroad where it was very successful. So lawyers protested, bar went on strike, but then they were convinced to come on board, they were forced to come on board, and they did. this center became successful for the sole reason that it is lawyer-run center. It was not run by judges. Judges convinced them, look, you come on board. And slowly the lawyers realized that it has it is very, very successful. I'd like to share some numbers. 42,536 cases have been referred to this center by the Delhi High Court, Supreme Court and other high courts. 13,179 cases have been settled with about 9,983 connected cases. These are not current figures, these are figures of last month. Now, these figures are only of the High Court Mediation Center. District Court figures run in lakhs in Delhi. The settlement rate in commercial cases in the Delhi High Court Samadhan is about 60 to 65%, with overall success rate of about 54%. And success rate of cases under Section 12 of the Commercial Courts Act is about 22%. That also is a very tremendous number. Parties are approaching the Center for Pre-Litigation Mediation, where the success rate is about 35%. And similar success rate is also of the Supreme Court Mediation Center, which is also run by lawyers. So this goes out to show that if institutional mediation is set up and run by lawyers, it can really be successful. You see, when you have judges running institutions, it's very difficult. Because when you are a trained judge, you become very judgmental. Every case you look at is from the point of view of deciding who's right, who's wrong. And that is exactly contrary to the concept of mediation. So my suggestion to the government and the stakeholders that when you're setting up the council, when you're setting up centers of court annexed mediation centers or these institutions, please ensure that they are predominantly run by lawyers. Madhya Pradesh has another success story. It has a success story of community mediation. Community mediation was attempted in Indore, and today it is conducted by retired academicians, bureaucrats, senior citizens, respectable members of the community. There are about 100 community trained mediators who are there. They have settled scores of cases. Every day they hold sessions. To an extent that the police commissioner in Indore gave up part of his office to set up a community mediation center there. So every day trained mediators, non-lawyers, community mediators go there, they settle disputes which are pre-FIR registered cases. Parties come together, of course, serious cases don't go there. Some disputes between parking issue, neighbor disputes, fight between brothers, they go there and they are settled. Success rate is pretty high. Now, the Chair, Justice Mishra, talked about capacity building, taking it to the villages. Now, how are these centers successful? How was it achieved? How did the Supreme Court and the High Court Mediation Center achieve it? First of all, like I said, lawyer-driven. The first thing that you have to do is identify advocates who can become mediators. Everybody is not cut out to become a judge, everybody is not cut out to become a mediator. So you have to identify them, give them extensive training, inculcate the feeling of dedication to serve, because we know as lawyers we would earn a substantial amount in the time that we spend, but mediators pro bono would work for hours and hours, days and days, session after session, and then even face a failure. But their dedication to the cause is immense, and that is something which we have to inculcate. Now, what are the skills that are needed to be inculcated in a mediator? Once you set up these centers, once you set up these institutes, one of the roles in the Act is train them. But what do you need to train them? You don't need to train them in law. You have to train them in negotiating skills. They have to know about different approaches to negotiation. How can they be used in parties in mediation to an effect that they have become a problem solver? Then they have to be trained in trust building. A mediator has to gain the trust of the parties. He is not deciding, he is making the parties come together. So another skill that is to be trained in is trust building, neutrality maintaining. The mediator has to be neutral. Parties should not even have a single feeling that, look, this mediator is taking sides. So he has to be trained, he or she has to be trained into give an impression that I'm completely neutral. The mediator has to be trained in facilitating the process, controlling the mediation process. We've seen cases where parties come into mediation, tempers rise, and the entire mediation process fails. So mediator has to know how to control the parties, because sometimes after years of litigation, when parties come there, they have been pushed to a corner, pushed to a stage where they are not in a position to even share the space with the opposite party. That is where the mediator's role comes in. That is where he has to gain the trust, ensure that he is controlling the parties. And the biggest skill that a mediator must have is listening and communicating. As lawyers, as judges, we only focus on the legal aspects. We are not ready to listen. But a mediator has to listen. And why listening skill is very important is sometimes you will realize that there are undercurrents, which parties themselves don't even know what is the undercurrent. It has to be a collaborative problem-solving skill. Now, when I learned my mediation, some of my trainers are here who taught me mediation. There was a problem that they were talking about, a dispute with two companies fighting over oranges. That's an example which is always used in mediation training. They were fighting over oranges, and the mediators were given that problem, that try and solve this issue. The simplest solution was divide the oranges half and half. That's the easiest way. We say, all right, split it into two. But the mediator would go deeper and found out that one wanted to make orange juice, the other wanted the marmalade. So one needed the pulp, one needed the skin of the orange. And both had a 100% success rate. Similar, I like to share disputes, some instances where I've had my training in mediation helped me. There was a partition dispute in Madhya Pradesh of brothers which came up before me. Now, there was no dispute on the share of the parties, it was a partition suit. So I told the parties, I said, all right, one of the brothers had a 22% share, the other side was 78%. There were three brothers on one side and one on the other. So I told the brother who had 22% share, I said, why don't you propose the value of the property? The others will choose. If they feel the value you are proposing is high, they'll sell you the property. If they feel it's low, they'll buy share off. So he said, I think the property is worth about 4 to 5 crores. The other brother said, no, it is worth about 10 crores. So I told the other side, I said, are you willing to put money where your mouth is? They said, yes, we stand by our offer of 10 crores. So I told the one who had 22%, I said, you were getting about 1.1 crore. Now they're offering you 2.2. Are you willing to buy or sell? He says, I'll sell my share. That dispute which was on for 25 years got settled in minutes. So there are several stories. Now the mediator also has to learn on reading the undercurrents. Now sometimes there are undercurrents in a dispute. I remember a dispute in Delhi High Court which I was handling. There were two Sikh brothers who came before me. They had longed on, they were aged, senior citizens, aged in court, and I looked at them and I asked both of them. I said, where do you come from? They said they come from a place called Karol Bagh. Karol Bagh is a place where I was born in Delhi. So, and knowing them, they looked very pious. So I said, where was your father taking you when you were kids? Which Gurdwara was he taking you? They said, so-and-so Gurdwara in Karol Bagh. This was at about 11 in the morning, that dispute had come up before me. So I said, do one thing. Both of you just go to that Gurdwara, sit there, listen to Kirtan, come back after lunch. So they both went. But I said, please don't discuss about the case. Just go there and sit there and listen to Kirtan for an hour or so and come back. They came back at 2:30 and the dispute was resolved. They really had no dispute. It was just ego. Similar instance I came across was a custody dispute again in Delhi High Court, where the wife had custody of the child who was 5 years old and father had visitation rights. So wife was a teacher in a school and she had an opportunity to go to Germany for higher education. And she said the moment I go for higher education, she was going for about 3 years, the husband was opposing it. He says for 3 years I will not have visitation on my child. So I am opposing it. We were fighting tooth and nail. So the wife said, look, I get this opportunity to go there to study. I don't want to deprive him. And once I come back, I'll get a jump, I'll get a boost, I'll become a principal in a school. But if he's so adamant, I will give it up. So I had asked the husband, what did he do? He says he works for an MNC and he was working from home. So I said, where did you both meet? So they both said, we studied in Germany together. So I asked the husband, is it possible for you to go to Germany to meet the child? He says, I can even shift to Germany for the 3-year period. So today they are living together as a family in Germany. So these are success stories which happen. You see, I always say mediation is not a vocation or a training, it's a lifestyle. Training in mediation helps one change as a person. I have changed as an individual once I underwent this training, and that training has helped me as a judge as well. So in conclusion, I would say that lawyers have to be on the forefront of mediation movement. This, I always say this and I would reiterate this. They bring an added dimension to the mediation of litigated cases in terms of their experience with the trial process, their knowledge of law, because without lawyers, we would not be able to draw up a mediation settlement. They practice at working things out with the opposing counsel, with the parties through negotiation. Whether a lawyer is acting as a mediator or lawyer is appearing in a mediation process, their role is very important. So we can't separate lawyers from the mediation movement at all. They have to be part of it, they have to be in the forefront. An enhanced understanding of mediation process with legal training and experience will help us achieve the goal, will help us achieve the purpose of the Mediation Act, and also transform the lawyers from gladiators to mediators. Thank you very much.
Thank you, Justice Sachdeva, for very interesting perspectives on the topic. I now circle back to Honorable Justice Prashant Kumar Mishra to close the session.
Now I will not take another 5 minutes to wrap up the session. The only message which, the one-liner which I could gather from Justice Sachdeva is, mediation has to be made a lifestyle. Lifestyle of justice delivery system. Lifestyle of pre-justice delivery system and pre-litigation system. And in the beginning, I could not mention Honorable the Law Minister of Odisha, who is here, and Justice Karol was also there, and Mr. Pitambar Acharya, he is restless, going in and out when this valedictory function will begin, and he has not listened to us as also. Anyway, we wrap up this session, and it was a wonderful 2-day conference on this mediation. The next conference will be in Meghalaya, as promised by the Advocate General of Meghalaya, and hoping to see you all in Meghalaya. And thank you, the organizers, Honorable Law Minister, Mr. Prithviraj, and the Advocate General, and all other sitting over here. Thank you so much.